Good morning, welcome to you all, or good afternoon, or good evening, whatever the time zone is when you're actually joining us. I'm welcoming you all to this roundtable, which is embedded in the Winter School on Federalism and Governance. The Winter School on Federalism and Governance is a cooperation project between the Eurac research in Bolzano, South Tyrol, the Institute for Comparative Federalism, and the University of Innsbruck. It's in its 14th edition, and it always welcomes participants from all over the globe. So we're happy actually to have again many participants from all world regions being here in Innsbruck this week at the Winter School. The Winter School is also a cooperation, and it also welcomes the form of federations as a cooperation partner, in the sense that we are very happy to organize this roundtable in cooperation with the form of federations that actually is the cooperation partner also for many academic projects, publication projects we have for the last years. So it's a pleasure for me also to welcome Tala Khrais as a country director from the form of federation. She sits together with many other experts on this roundtable. The topic of the roundtable today is federalism and gender equality. And this is also the topic of the Winter School edition this year, in the sense that gender is an important topic when we talk about federalism and equality, or federalism and inequalities, however one may frame it. So for my part, I'm Elisabeth Almer from the Institute for Comparative Federalism. This is all. Last, I would like to welcome and thank in advance also Professor Marcelo, who is moderating and facilitating this roundtable. He's professor at the University of Innsbruck, has been also professor and academically active in many other universities, including the University of Vienna and University of Mannheim. He's an expert on parliamentary studies. He's an expert on party politics, on regional, subnational politics, and he will guide this round table. Let me now give the word, before handing it over to Marcelo as a facilitator of the roundtable, to Tala Khrais for the welcoming note on behalf of the Forum of Federations.
Thank you, Professor. On behalf of the Forum of Federations, I'd like to welcome all participants to this roundtable on federalism and gender equality. The Forum of Federation values its continued collaboration with the University of Innsbruck and Eurac Research Institute for Comparative Federalism at the University of Bolzano, Italy, and thanks them all for their work on organizing this roundtable event. The Forum is an international organization that develops and shares comparative expertise on the practice of federal and decentralized governance. Our mission is to strengthen democratic and inclusive governance in established and also in emerging federal and multi-level countries through knowledge creation, mobilization, capacity development, and support to inclusive policy implementation processes. With the support of our partners, the Forum has sought to advance this mission by integrating gender equality as a cross-cutting theme across different theoretical and practical work. As a preeminent public policy issue, examining and understanding gender issues in the context of different governance systems is of a critical importance. Learning from each other about the opportunities and challenges that federal and multi-level systems provide when it comes to advancing gender equality allows us all for and encourages continued discussion and debates concerning the role of government and other actors in supporting gender equality initiatives and policies. Thank you once again to our partners, my fellow speakers, the participants for being here today, for convening this roundtable on this critically important issue. At the end, I would like to add my welcome note with a quote from a lawyer and an expert on federalism, Elizabeth Price Foley, who said, "Federalism isn't about states' abilities, it's about dividing power to better protect our individual liberty." Thank you very much.
Okay, thank you. A warm welcome from my side. The topic is already quite clear. I will say a few words about the format. We will have a short presentation of the three speakers on the podium, then 2 rounds of questions that will be answered by the speakers here, and then we open up for questions from the audience before we conclude. Okay, let's start with the presentations. To my right, Professor Erin Delaney, who is Professor of Law and Professor of Political Science at Northwestern University. She has degrees from both US and British universities, highly prestigious ones, Harvard, University of Cambridge, New York University. She's a specialist in comparative constitutional law and federalism, and as I've seen from her publication, she's working, coming from both law and political science, she's working at the interface between law and politics, which is highly interesting to me. Currently federal scholar and resident at Eurac, still correct. To my left, Ms. Tala Khrais. She is, as you already indicated, Jordan's country director in the Forum of Federations project. She had extensive experience in managing donor-funded projects. She has a degree from McGill University in Canada with further courses at European institutions. And further to my left, Professor Rekha Saxena from India, from the Department of Political Science at the University of Delhi. She's an expert in Indian politics, expert in both Indian federalism and comparative federalism. She is a prolific producer of academic books, with a recent book on the latest Indian elections and on Indian federalism. So, to be very short, because in the first round you have more time to present yourselves and your interest in this topic, how you relate to this topic of how federalism and gender equality or inequality go together or don't go together. We frequently hear arguments that having a federal or a decentralized state structure opens up room for innovation at the subnational level. At the same time, well, there is room for subnational variation, and that means also with regard to that topic, you can stop reforms at the subnational level. And I want to ask Professor Delaney to start with her first presentation.
Oh, thank you. Thank you very much. It's wonderful. Thank you to Eurac. Thank you to Innsbruck. Thank you to the Forum of Federations for hosting this wonderful panel and including me with absolutely impressive and marvelous speakers that you will hear from. You've already heard from me quite a bit yesterday, those of you in the room. So I'll just sort of briefly say a couple of comments. One, you know that I'm a constitutional law professor, and so I'm very interested in the way in which constitutional law operates to structure questions of equality in the United States in particular. And my research, though it's mainly on federalism and rights at a more general level, does cover some areas of gender equality or inequality in the United States. And I think we have some meaty questions that are coming up, so I'll save most of my remarks for the response to the questions. I think one thing to think about in our conversation today is whether there's sufficient variation in cultural norms across a country to allow for significant variation among member states on issues like gender equality. And in the United States, we have an added overlay with some complications of legal terminology. So our main statute uses the word sex, not gender. So how do we think about biological sex, gender, sexual orientation, and the ways in which those words might carry some kind of legal meaning? And you see the justices of the Supreme Court wrestling with that kind of legality that overlies kind of real lived experience for people. And so there's not always a great relationship between those two things, which I'll talk about more in my remarks. I was fortunate to clerk on the Supreme Court for Justice Souter when he was a justice before he retired. And so understanding a little bit about the processes of the Supreme Court decision making is also useful to thinking about the role in which our constitutional system flattens or attempts to unify rights across the nation and how much space there is therefore for subnational variation. So I will stop now. You've heard from me. Turn the microphone over and look forward to discussing more about the United States in due course.
Okay. Professor Saxena, may I ask you for your introductory remarks?
Okay. A very warm welcome to everyone. I am Professor Rekha Saxena. I teach political science at the Department of Political Science, University of Delhi. And I've been working on federalism, for almost 3 decades now. And as you all know, that India is the world's largest federal democracy. And so I have been working on different aspects of federalism, and I've been closely associated with form of federation for over 2.5 decades. And so with regard to the topic for discussion today, I think there's no dearth of literature on federalism and gender. But you will hardly find any literature that tries to establish the link between federalism and gender. And Sowers and Beakers, they have written on this. And then I have been working on different dimensions, but I started thinking most of my students, I thought I'm not working on, I'm not a feminist, but then many of my students here started working on gender. So I got interested and I started wondering, is there any relationship between gender and federalism? And then I, decided to work on some certain variables like factors that play an important role in this establishing relationship between gender and federalism, like asymmetrical federalism. Does asymmetrical power relations impact federal systems? Like different states, they have symmetrical or asymmetrical relations. So does it play an important role? Then second indicator that I started was, distribution of powers. How does distribution of powers, distribution of responsibilities in different federal systems, they impact women? Because there's no one model of federalism. It has wide variations. Some are centralized, some are decentralized, and some federations will find more powers are given to federal government. In other nations, more powers are given to subnational units. So there's no one ideal model. And then I talked about financial relations, like how far fiscal relations they impact women, revenue sharing, gender budgeting, how does it impact the condition of women in federal countries. And another important indicator which I find is intergovernmental interactions. Because in any federal system where different levels of government exist apart, there's need for interaction. So what are the mechanisms? What are the platforms where different levels of government could interact? So where are the women in these groups? Are they part of these interactions or they are outside? Because for example, in Canada, First Minister's Conference, that's the Apex Intergovernmental Forum. And one of the criticisms is that it is an elitist body. 11 men in suits decide for the entire nation. So women are kept out of the, decision making or consultation process. And then Another important term which I'll be discussing, I don't want to cover all, it will be there in the Q&A session. So forum shopping and financial relations I've already talked about. So these are some important aspects I thought that tries to establish a link between gender and feminism, which I'll be also discussing during the course of our discussion. Thank you so much.
Thank you. Ms. Tala Khrais.
Thank you, Professor. It's very difficult for, let's say, practitioner to talk about himself or herself. But I can say I'm an ambitious Jordanian woman who will always seek the know-how, but also is also concerned about transferring the know-how to fellow citizens in Jordan. And so after working so many years in donor-funded projects, Jordan started its decentralization process in 2016. And there I was intrigued to learn more about decentralization and also seeking information and knowledge from, let's say, international and European institutions first. So I was lucky to, pursue courses at the College of Europe in Bruges. Then I also took courses at Turin School for Local Governance in Italy. I also went to seek further information at other schools like the Hague Academy for Local Governance. And all this knowledge and information built my capacity to be able to participate with fellow national experts in Jordan. I can say I was not part of drafting the legislation and decentralization process, but I was part of the experts who delivered the know-how and across to all the elected council members and communities in Jordan about the decentralization law and its implications. Then, as for the gender equality, I was also fortunate to work for the Forum of Federation at a global funded Canadian project on empowering women for leadership roles. And this is a regional project that covers Jordan, Tunisia, and Morocco. And the project is really targeting empowering women decision makers in the three countries. And when we are talking about decision makers, we're talking about elected decision makers, like parliamentarians, council members, whether they are municipal or local council. In addition to the fact that we also build the capacity of future women leaders. This means that they are women who are starting their career, so they might be young members of political parties. They can be students at universities. As you know, not all students have the applied skills to be able to become politicians. So we try to target all students, in particular those who lack these skills. For example, debating, negotiation, crisis management. They are all skills that are required for future politicians to be able to participate in political life. In addition, in order to empower women and advance gender equality, the Forum of Federation also targets what the communities in the sense of awareness. Awareness is very important to allow for this cultural norm shift towards empowering women and gender equality. And this awareness can be through, let's say, research papers, through interaction with communities on awareness sessions, through videos, radio programs, all various types of awareness that will advance gender equality at a national level. And finally, we also seek collaboration with civil society organizations, academic institutions, and government entities together in order to advance gender equality in Jordan. So let's say this is how I gained, let's say, information and knowledge and practice in both decentralization and gender equality. Thank you for your time.
Thank you. Okay, the first question will be on the legal protection of human rights, because they're provide the tools to challenge gender inequalities at the workplace, in public life, in your home. And the first question is, how does the Constitution and the legal system of your respective countries protect women's rights and provides these tools to fight gender inequality? And I'd like to start with Professor Saxena.
Thank you so much. I think the Constitution of India has an elaborate provisions for protection of women's rights. And we start with part 3 of the Constitution on fundamental rights, where Article 14, 15, 16, they all talk about, upholding the principle of gender equality in India. And Article 14 argues that all are equal in the eyes of law, and all are equally protected by law, and equal political, economic, and social rights and opportunities, they are all included in these articles in the fundamental rights. And there's no gender discrimination that is prohibited. And especially Article 16 of the fundamental rights talks about, equal opportunity in matters relating to employment, appointment to any office, regardless of religion, caste, creed, and gender. Then I would also like to refer to Article 21 of the Indian Constitution, which is very important, that talks about right to life and liberty. And it is particularly important because it protects women against violation of bodily autonomy and is understood as part of their liberty. Further, and fundamental rights, they are justiciable, in the court of law. If they are violated, you can go directly file writ petition. Writs, they are written. Writs are written orders by the Supreme Court to provide constitutional remedies to protect their rights under Article 32, and in case of Supreme Court, and Article 226 in case of High Courts. In fact, when my rights were superseded, I also filed a writ petition in Delhi High Court. So besides fundamental rights, there in part 4 of the Indian Constitution, there are directive principles of state policies, which are, the ideals, what ideals that state should follow while formulating policies. From Article 39, Article 41, 39 talks about in detail equal subsistence and compensation for equal work. Article 41 talks about state must guarantee right to work, education, public assistance to all citizens within its economic limits. Article 42 talks about human working conditions, maternity leaves, and then Article 46 argues that talks about protection from any kind of social injustice and all forms of exploitation against women, and particularly Article 47 of the Directive Principles of State Policy, that talks about improving public nutrition and living standards, as well as public health, among other things. Because, malnutrition and nutrition, they affect women more. So these are some directives which are given by the Constitution to the state, but they are non-justiciable. They are just directions. So you cannot approach the court if they are violated. And they are both fundamental rights and directive principles are basic features, they constitute part of the basic structure of the Indian Constitution, which cannot be destroyed. Besides constitutional rights, there is legal protection which is given to Indian women under the 1860 Indian Penal Code, which is codified and covers almost every aspect related to crime against women. It contains provisions for punishing those who commit crime against women, which is given in sections of IPC, like offenses like acid attack, kidnapping, abduction, attempt to commit rape, outraging the modesty of women, sexual harassment, stalking, a word, gesture, or act intended to insult the modesty of a woman, and so on. So these are some important, provisions which are given in Indian Penal Code to protect women, but they have been amended from time to time, considering social realities. Besides, there are many parliamentary laws leading to protection of women, like Immoral Traffic Prevention Act, Dowry Protection Act, the Commission of Sati Prevention Act, Prohibition of Child Marriage Act. So from time to time, there have been new laws and acts which have been incorporated. And the most recent, there are many, so I'm just mentioning few which are important. And the most recent and significant act that was added was the Sexual Harassment of Women at Workplace Prohibition Act 2013. That's the latest, entry to this. Further, the courts also play a very important role in protecting women's rights, and Indian judiciary is the most powerful, especially the Supreme Court, the most powerful Supreme Court after the American Supreme Court, with its power of judicial review and activism, and by enforcing, strengthening constitutional goals towards protection of rights. And I would like to mention some very important cases. One was relating to Air India, in which the Air India had laid some guidelines that women, after joining, they cannot marry for 4 years, and if they are pregnant after 4 years, they have to terminate their job. So the women went to the court in Air India versus Nargesh Mirza case, and the court argued that it was violative of Article 14, and the termination of job on first pregnancy conflicted with Article 14, right to equality and fundamental right. Then there was very important Vishaka judgment. It was covered in international media also, that 5 men gang raped a woman, Bhavri Devi. And she went to the court, but the trial court acquitted all 5 accused. And then her case was taken up by this women's education research group, Vishaka. So in this case, Supreme Court issued some guidelines, Vishaka guidelines, that defined sexual harassment and placed the onus on the employee, that they have to provide free and safe working environment for women. Then there's another important case, Dhanulal and others versus Ganesh Ram and another in 2015 with regard to live-in relationships. And because in India, marriage is a norm, whereas live-in relationships, they are exception. So according to Supreme Court, coupling to the Supreme Court, couples who live together would be legally considered married. And it was also decided that the partner died, the woman in relationship would be entitled to inherit the property. Then there was another interesting case in 2018, Joseph Shine versus Union of India. Now in this case, the Supreme Court unanimously struck down Section 497 of Indian Penal Code, and the court argued that a woman's consent for physical relationship or its violation after marriage is against the constitutional values and constitutional morality. So, but I feel we need to have more stringent laws against marital rape, which still remains legal in India. So, due to some cultural, beliefs and the faith in the institution of marriage. Now, in another important judgment concerning the entry of women of reproductive age, to a temple in Kerala, Sabrimala temple, because in India menstruation is taboo, and it is believed that the women who are menstruating, they are less pure and they cannot enter temple. So the conception of constitutional morality was invoked in this case, and in Young Royals Association versus the state of Kerala 2018. And then, so the conception of constitutional morality was invoked, and they were granted entry into the temple. But there are some loose ends, I would say, although we have extensive laws and justice system, but there's still a question of societal change, patriarchal mindset that needs to change. That is a real question that we are discussing in India. And as a person, I think why still there's objectification of women. I'm a well-qualified professor, internationally recognized, but even in public spaces, I've been objectified in professional spaces also. People will, make not commenting, but more commenting about your personal experience. Just to cite one example, I visited. I was an examiner to defend for a PhD Viva, conduct a PhD Viva in a university in Delhi, and the same day I got a message from the professor, supervisor of the candidate, with some objectionable message. So it's why you are, objectified. That needs to be, understood. So I would end here. Thank you so much.
Thank you, Professor. Ms. Tala Khrais, please, on your observations on the Jordanian or on the MENA cases.
Yes, allow me, Professor, to the coming 10 minutes to take you into a journey on gender equality in the MENA region, the gaps, and then we can focus more on Jordan regarding its constitution, its legislation, whether it is with or against gender equality, what are the advantages and drawbacks, and maybe look further into the decentralization law in the further on if we have time. Just to mention that the recent gender gap report for 2022 by the World Economic Forum mentioned that the MENA region is the second lowest in terms of regions, in terms of gender equality. And the report had the title that that the MENA needs more female leaders to close the 115-year gender gap. So the lowest region is the Southeast Asia, followed by the MENA region. And well, so the MENA closed only 63% of its gender gap. Part of this, the slowdown in gender equality in the MENA region might be as a result of the recent pandemic, whereby many women in the MENA region lost their jobs due to the pandemic. When in particular small and medium enterprises decided to downsize their work, they start with women firing them, and there are times where professional women decided to leave work because they couldn't balance between the caregiving tasks they had and also the professional life. In addition to the fact that there were many women entrepreneurs in the MENA region who started their businesses, but they could not cope with the crisis, and they had to lose their dream or businesses. So, in addition, we have other challenges. The climate emergency. I come from a country that is the lowest, maybe the second lowest in terms of water resources. So women are the most affected when it comes to climate emergency. Also, we are surrounded by countries with conflict and displacement, and we have high number of refugees in Jordan. And the current crisis, the war, it has resulted between Ukraine and Russia in rising food prices worldwide, including Jordan. And women and other segments of societies were affected by all these conditions. So, therefore, just to mention that the report mentioned that we have to assist women to return back to workforce in the MENA region. All governments, international organizations and civil society organizations have to work all together to ensure that women are back, including, for example, introducing more flexible working hours in the MENA region, and also assist women to access what's known as the industries of the future. Focusing on Jordan more, Jordan ranks 5th in terms of gender equality in the MENA region. And so number 1 in the region is Israel, followed by the United Arab Emirates. And Jordan, as I said, is number 5. But at the same time, the report mentioned that Jordan is one of the 3 countries in terms of economic parity. It means that, we are trying to reduce the gap in wages between women and men in Jordan. Now, as for the current legislations, in particular the constitutions, may I quote that the recent approved changes in the Constitution, Article 6, on the 2nd chapter of the constitutions, mentioned that Jordanian men and women shall be equal before the law, and there shall be no discrimination between them as regards to their rights and duties on grounds of race, language, and religion. Previously, it was only mentioned as Jordanians without specifying whether they are male or females. And in addition to that, in the same article, it mentioned that the state will guarantee the empowerment and support of women, youth, and disabled to play an active role in building society in a way that guarantees equal opportunities on the basis of justice and fairness and protects them from all forms of violence and discrimination. So here, the Constitution concentrates the fact that the states has a role in empowering women in Jordan. Now, commentators to the amendments to this constitution, which recently occurred in 2022, mentioned, well, it's good to have all this, including a woman clearly in the constitution, but how about if there is a breach to this constitution? There's no clear, what are the sanctions to this if the breach is happening? In addition to that, there's no clear roadmap for the government how it will reach the 2030 ambition to have equal rights, between men and women. In addition, the Jordan cabinet approved the National Strategy for Women 2020-2025. It means that all ministries, governmental entities should include that strategy whenever they are creating or developing their policies at ministerial level. And also, they are encouraging, let's say, elected councils, municipalities, to also include this strategy into their local policies. Now, despite all the concentrated efforts, there are still gaps, there are still drawbacks in certain legislations in Jordan. To name a few, for example, the famous nationality law. In Jordan, men are allowed to transfer their nationality to their children by blood, while women cannot. So if a Jordanian woman is married to a non-Jordanian man, she cannot transfer the nationality to her children. And also there is the penal code where there is no definition in that penal code of violence against women or domestic or family violence. In addition, the personal status law, it means, the law that regulates the personal status of people in Jordan. As you know, Jordan, the two main religions are Islam and Christianity. So this law regulates the personal status of Muslims. And it is not, women and men are not equal in front of this personal status law. And there are many examples. For example, in the case of guardianship for children, it's men who are the guardians of their children. When it comes to divorce, men and women are not equal in terms of divorce. And, also the law allows polygamy for men in certain conditions. So men and women are not equal in front of this personal status law. As for Christians, as you know, they belong to a number of denominations. There are certain Christian denomination laws are not what you can say published in the official gazette, so it's not clear how the personal status is being followed for these Christians. In addition to that, we can find that there is a lot of debate, there's a lot of discuss, and it's not clear. So that's why we have gaps in issues in that level. So in summary, allow me to say that certainly the articles of constitution, the text of laws, as well as the electoral systems that I will talk about later on in the decentralization part, they can serve as a driving force of social progress through compulsory mechanisms. But this must be accompanied by other mechanisms to enable women and allow for better gender equality in the medium and the long term, to seek access to decision-making position by means other than the constitution and the legal framework. Thank you.
Thank you. Professor Delaney.
Thank you very much, and thank you for those two presentations. I learned a lot. I appreciate that. United States. So, first of all, I'm going in these remarks to focus a little bit more on women than on gender or sexual orientation, but we will get there. LGBTQ+ or gender non-binary persons have not gotten the same level of protection at the constitutional level as women have, and I will walk through that. But there's some movement on statutory footing. Another thing to know about the United States is that it's very hard to talk about any group as a monolith, right? So if I'm to talk about women, well, you can break that apart, and intersectionality in the United States is very important. So even with something like the response, the results of COVID, as you mentioned, and women in the workforce, that has hit Black women and Latino women harder than it has hit white women. So there's a lot of complexities, and to the extent that I'm flattening some of those complexities in my remarks, I'll try to draw out nuance where possible. But at a high level of generality, I want to talk about sort of the constitutional provisions and the statutory provisions in the United States that deal with women's rights. So not much happens in the 19th century, although there's a lot of efforts to promote women's equality. As you will remember from our conversation yesterday, right, the federal government doesn't have much authority over day-to-day life. Right, it's common law that comes from England, is very sexist, it's embedded in the states. So things like divorce, the relationships within marriage, criminal law, all of that is state level activity. And until the passage of the 14th Amendment, the federal government can't really reach into state level activity that much. In 1919, the 19th Amendment or 1920, the 19th Amendment is passed. This is the amendment that allows women to vote. And so there's a sense that this is going to be the harbinger of change, right? We now have active women in political participation. Obviously, in much of the country, this is white women who are able to vote at the time because of Jim Crow. And in 1923, the first Equal Rights Amendment is proposed. Doesn't move forward. So not much actually happens. Voting matters, and it does help in some ways. But the real agency of change is the 14th Amendment and the application of the Equal Protection Clause and the Due Process Clause to activities in the states. The litigation strategy that really pushes this forward for women is designed in large part by Ruth Bader Ginsburg, who brings cases to the court attacking gender discrimination, stereotypes, and often she's bringing forward cases on behalf of men. So a man isn't allowed to do something because it has been given to women, or men can't drink a certain kind of beer, but women can because they think women will be more responsible about drinking beer. Well, that's also itself a stereotype about women and men. So there's a lot that's been written about whether this approach to tackling gender equality by foregrounding men has or hasn't been successful. But the idea was to use the Equal Protection Clause to say that women or men are not being treated equally. In the context of race, which we talked about yesterday, the court will do a very searching inquiry. It's called strict scrutiny. They look for a compelling reason to allow differentiation. And that reason has to be narrowly tailored. The result has to be narrowly tailored to the goal. So it's very hard to make race-based classifications. In the context of gender, though, the court, when this had begun, all male court, right, believed that there were real differences that would justify different treatment. And so a lot of the early cases and even later cases turn on the sense of whether or not there's a real difference or if that difference is a stereotype. When Justice Ginsburg eventually gets on the court, she in 1996 suggests that the test should be a genuine need for this different treatment that is exceedingly persuasive. And she believes around this time that the evolution of the equal protection doctrine, has functioned in the same way that an equal rights amendment would. Things changed, right? Not long after that 1996 case, there's a case where Justice Kennedy made a decision, a case called Wynne versus INS, where he says, well, we can treat men and women differently, again, in a situation of passing on citizenship. Because we know that women, well, first of all, they give birth to children, which is a real difference. But then they're gonna have an emotional attachment because of that men won't have. So again, sort of stepping from a potential real difference to a stereotype about what that real difference might create a natural bond between the woman and the child. Happened very quickly. A very famous case called Geduldig is one of the cases that demonstrates how this real difference or this conception of pregnancy is not taken seriously by the court as an element of discrimination. So the idea that women might be discriminated or subjugated because of their reproductive capacity itself has not really taken hold. In Geduldig, there was a provision that excluded pregnancy-related disabilities from coverage for healthcare coverage. And the court said, well, this isn't really a gender-based or sex-based discrimination. There are pregnant persons and non-pregnant persons. So an unwillingness to link pregnancy to gender or sex, and again, these are complicated, now much more complicated terminology than at that time in the 60s, meant that using the equal protection clause for pregnancy related issues was kind of a non-starter, which is why you see the abortion litigation come through the due process clause. So we move away from women's rights connected to pregnancy to the idea that there's a right to privacy, which comes from the idea of liberty in the due process clause. You have a right to liberty can't be impinged without due process of law. So what does liberty entail? Well, the court says in a case called Griswold, liberty entails a sense of privacy that extends to use of contraception. And that then case eventually becomes Roe, that leads into Roe, but not the case, the reasoning, which then is extended to the idea that privacy encompasses a woman's decision whether or not to terminate her pregnancy. Because of the way that that doctrinal evolution happens in due process, becomes unstable law, as we have recently seen, and the right has been removed. It's not tied to gender. And so you see different ways in which women's rights or considerations for women's rights have developed because there isn't really explicit guarantees within the constitutional system, within the written constitution. They come out of equal protection, come out of due process, and litigation strategy, as well as who's been on the court, sort of set it up in different ways. The most recent case, one of the more recent cases before this past term was a case called Hobby Lobby, where again, the court was unwilling to extend protections to women related to their contraception choices, their sexual health choices. And it all was sort of tied into this sense that the court hasn't grappled with, again, this discrimination and subordination attached to reproductive capacity. On the other hand, so that's the constitutional framework, and I will in the next question talk a little bit about the Equal Rights Amendment and what's happened in the states with state Equal Rights Amendment. On the other hand, statutorily, we have Title VII, which does a lot of work in employment discrimination, and the language there is on the basis of sex. And that has been a driver for women's equality in the workforce, for the ways in which discrimination or abuse in the workforce can be tackled. And recently, that phrase on the basis of sex was interpreted in an opinion by Justice Gorsuch to include sexual orientation. We haven't seen cases that engage directly with gender non-binary people, trans people, but there has been a stretching of that understanding of the word sex to include sexual orientation in the Title VII context. The court has not treated people in the LGBTQ+ community as deserving of higher scrutiny. So they do not get protected class status in the way that race requires heightened scrutiny, or that sex, gender, women versus men has received heightened scrutiny. What does that mean? It means that in a case like Obergefell, where you see a due process right coming out of this right to marriage that's kind of intertwined with an idea about discrimination on the basis of sexual orientation. What the court hasn't done is say discrimination on the basis of sexual orientation is suspect. So we will always look at it more rigorously. And if you have that statement at a legal level, it means that you operating in your community might be passing a law based on about housing or adoption, right? Know that your decision is going to be looked at more closely. Instead, what it means is that every law has to be challenged, and you have to show that it's actual discrimination happening there at that moment, and that it's driven out of animus. So it's a much more complicated and heightened effort that has to be made in the litigation process when you don't have the sense that the court has already accepted kind of discrimination on this basis as something that is deserving of heightened scrutiny by the court. So that kind of gives you a sense of where the constitutional law stands. The statutory law and the interpretations there, it's moving forward, but yet not as far forward as many would hope. And certainly kind of the new claims for gender non-binary trans people are at their infancy, just starting. And the old claims that have been kind of percolating along on areas of reproductive discrimination and pregnancy have not moved forward. And the decision by the court to overturn Roe has set them back, more affirmatively set back. So that's sort of the constitutional and a tiny taste of the statutory landscape in the United States.
Thank you. Our second round question will be on the relationship between the state structure and gender inequality. How does federalism, how does decentralization either further support moving forward on the topic, or how does it hinder such reforms? And I'd like to start with Mrs. Rekha.
Thank you. To start with, going back to the MENA region, as you know that in 2011, when the Arab Spring started in the region, and people went into the streets calling for dignity, for human rights, for better welfare. As a result, you know, many of the Arab countries who did not end up into civil war and crisis, they started to undergo some sort of decentralization and also empowering local level of governance. And one of them is Jordan. So let's say decentralization is regarded as a prerequisite for the establishment of a true democracy. It would close the government gap in public service, ensure effectiveness and efficiency of local government, and give local councils legitimacy. It's also argued that decentralization will reduce gender inequalities in politics by opening up the political game to multiple level sides or scales of government. So Jordan started its process examining decentralization, and in 2015 we ended up with the first decentralization law in Jordan, and in that law we had 3 levels of governance. We already had what's known as the municipal councils. As you know, Jordan had municipalities even before the kingdom was established. During the Ottoman Empire, we had municipalities in Jordan. So Jordanians are used to municipal work, but then in this new law, we have what's known as the governorate councils, which is a governance on top of the municipal councils. Jordan is made up of 12 governorates, and we have a lower level of governance, what's known as the local government or local governance council. So we had the election in 2017, and I guess women at that time in Jordan were thought that this is a promising law. So we had 7 candidates to become mayors in Jordan, women candidates. And as you know, Jordan has Jordan has 1 experience of a woman mayor. In 2003, we had a woman mayor in 1 small town south of the capital, Amman, and this is the only case of a woman mayor in Jordan. So women went into election. And according to the election law, we had quota. The positive discrimination in a sense that the 25% of municipal council were going to be women, and we had 15% of the government council and the local councils were expected to be women. So by when the election was finalized, we were happy to see that there were women who reached the councils even in competitive basis and not only through competition. So we had 241 seats won by women on competitive basis and 549 seats on the quota system. So 175 municipal council seats were kept for women, 342 local council seats were women, and 32 governorate council seats were won by women. So now Jordanians we're used to having women in decision making at local level after this law. But I have to say that this 215 law, yes, it gave the mandate for the councils to, let's say, plan and budget for local development projects at governorate or local or municipal level, but execution was kept into the hand of the government. So the governor and his executive directors are the one who will execute these projects. After 5 years, the government decided to amend the project. The law, and have what's known as the local administration law of 2022. In this new law, the local councils were abolished. So we have no more local councils, and they kept the municipal and the governorate councils. And they increased the quota in the governance council to 25% for women. So the election that followed this new law, we noticed that there was no women who ran to become mayors. And they only went to become council members. They were candidates for council members. So as a result, the percentage of women who won through competition, the percentage was less. So there were only 68 women who won by competition, and the others were part of the councils based on the quota system. Well, if you want to compare what's happening in Jordan to the other 2 countries in the region, for example, Tunisia. In Tunisia, the closed in Tunisia's 2014 constitution demonstrates that the intention to increase women participation in local politics. So the constitution is clear. And also the Tunisian gender equality electoral list mandate assisted more women to be elected to be in leader position at local level and national level, because in that electoral list in Tunisia there will be an equal male and female ratio of political candidates on the country electoral list. As for Morocco, both Morocco and Jordan are kingdoms, but Morocco started its decentralization process earlier than Jordan, so it was in 2011. And the efforts were made, to have an impact on women empowerment. So there were constitutional changes that demonstrated the desire to promote democratic governance. But at the same time, in the case of Morocco, there's still work to be done to set up a participatory arrangement to enhance dialogue and consultations with citizens and NGOs to increase community participation in the level of local government and decentralization. In summary, may I say that decentralization means more positions to be filled. So there's more access to women in decentralization process. So opening up the political game with multiple levels, sides and scales of government, and women find it easy to access the local level rather than the national level politics, because too many reasons, including financial wise, it's easier for them to access the local level politics. So they are more willing to compete at that level. The electoral systems, laws on political parties, inclusive laws are a necessity, but not sufficient condition to increase women participation in public and political life. It's very important to sensitize communities on the importance of women participation and to convince citizens to vote for women. And finally, we believe that working with young people and building their capacity as new generation is very important to ensure sustained women empowerment at local level. Thank you very much.
Thank you. Professor Delaney.
Thank you. So I'm going to talk a little bit about the Equal Rights Amendment because I think it's an interesting example of this kind of devolutionary situation in the United States, or the way in which federalism may or may not be helpful. So the Equal Rights Amendment was proposed first in 1923, as I told you, proposed in Congress, but did not get approved by Congress. It was reintroduced at every Congress between 1923 and 1972, where it finally got approved and sent to the states. It was given 7 years for ratification, extended to 10 years, but they could not get the requisite number of 38 states. If you're interested in the history, there's an excellent book by a friend and colleague named Julie Sook called We the Women, about the history of the Equal Rights Amendment. In 2020, perhaps as part of the push towards a renewed attention towards women's rights out of the Women's March in the wake of the election of Donald Trump, Virginia became the 30th state to ratify the Equal Rights Amendment. So now there's a question about what will happen. There was a timeline. Some states have claimed that they rescinded their ratification. So this is an interesting kind of legal problem that's confronting the United States right now. But in the intervening time, actually, even before the Equal Rights Amendment was proposed in Congress, Wyoming passed one for its own state constitution in 1890. And a number of other states have either equal rights amendments in their state constitutions or provisions that operate similarly to an equal rights amendment. So there was sort of this idea that maybe the approach within the states to this concept of equal rights would demonstrate some kind of variation or the benefit you might see from the laboratories of democracy in a federal system. And so, I hadn't looked very closely at whether something did happen. There's a lot of writing about an occasional case or two where states with equal rights amendments done something different from the federal government, from the Supreme Court. So one example has been that is now even more complex, but a historical example was that the Supreme Court said the Hyde Amendment limiting access to abortion, limiting the whether or not government funds could be used to pay for abortions was acceptable possible under the US Constitution. And in New Mexico, which has an Equal Rights Amendment, and Connecticut, state courts said that that kind of limitation at the state level was not acceptable. So there are these sort of examples where you might think that this kind of space for different interpretation is possible, and in fact, it is possible. But in a recent article, 2021, by Madeline Tischhofer and David Schultz, they looked more closely at the 703 cases out of the, according to them, 26 states. Other people say there are 28 states. It kind of depends on how you classify the non-exactly similar amendments, if they really function as equal rights amendments or not. But they gathered a data set of 703 cases and suggested that there were actually very few cases where anything really meaningfully different happened, and in some cases there was a certain amount of retrenchment. More interesting in this article, I thought, was their efforts to identify whether there was any correlation between states with equal rights amendments and on the ground change for women, sort of lived experience. Things like pay rates, women in the United States do not make the same dollar for dollar as men, but it varies by state, and some states, it's as low as I think 68 cents, and some it's as high as 90, somewhere in their high 80s. But they found no correlation between states that have equal rights amendments and pay rates. They found no correlation between states with equal rights amendments and representation in government. How many women are involved in state government? So some of the markers that you might think of as progress or as indications of equality don't seem correlated with this kind of legal change at the state level. And so I think that raises a number of questions. One is a question about law in the face of entrenched discrimination. One, and how much it can change how people view one another. One is a question that may be about the I don't want to say distorting, because the debate over abortion is incredibly important, but maybe just the amount of oxygen that is taken up with that particular debate and what is left for some of the other legal moves and engagements on women's rights. Although of course abortion is a frontline issue, so it's hard to quantify how to even think that through. But to the extent that state ERAs have been applauded in some areas on reproductive rights, they don't seem correlated with these other areas of women's equality. So that's a complicating feature. And then finally, I think that the variation and ability for variation is probably more at the state legislative level, policy making, than at the state constitutional or federal constitutional level. But the sense in the United States of federal constitutional rights, and I mentioned yesterday this book by Jamal Green, How Rights Went Wrong, and the idea of what rights have to be uniform and not, I think places a lot of attention on the Supreme Court as the agency, as the not agency in a governmental sense, but as the actor that can create the uniformity that people are looking for. And so the focus on kind of winning it all at the central level has left state constitutional law and some of the ways in which variation and experimentation might be used sort of as a backseat. And this is something that's been talked about for decades. Justice Brennan wrote a famous law review article exhorting people to turn to state constitutional law. If there's going to be retrenchment on rights at the center, if the Supreme Court is going to start limiting rights or not continue the efforts made in the middle of the 20th century to expand rights, let's go to the states and yet it has never really taken off in the way that that many of its proponents had hoped. So that strikes me as a sort of a cultural commentary about the way in which rights are discussed in the United States, whether it's gender equality or other areas of rights, and this pressure towards uniformity that that puts all of these debates on a national level.
Thank you. Professor Saxena, India.
Thank you very much. I think as the Forum of Federation Studies, they argue that the federalism has both advantages and disadvantages for gender equality. So, but I think it depends on the nature of the federation, whether it's a centralized federation, whether it's a decentralized federation, and historical and cultural context. That is very important, and especially the will of the political leadership, that is also a very important factor. So you will find there are wide variations, in this, and starting with the advantages of federal model of governance, I think it may generate different opportunities, and because federal system has different levels of governance. So it provides more public offices and expands opportunities for women's democratic participation. So national losers can become regional winners. If you lose at the national level, you can contest at the state level. If you lose at state level, you can contest at the local level. So it deepens democracy. Secondly, I think in addition to providing opportunities for women to enter public offices, multiple parliaments or legislatures, they provide multiple avenues for women to advocate for reform measures, and what gender scholars call it as forum shopping or venue shopping. Okay, like if national government is conservative and opposed to gender equality measures, women advocates can instead lobby at sub-national governments. So that is a very important advantage of a federal system or a decentralized model. Thirdly, I think a federal model of governance promotes policy transfers within a government. So it accomplishes this by instilling, competition among sub-national units and allowing them to allowing the success of one sub-national unit to serve as positive example for another. So on one hand, there's some kind of provincial Darwinism that you see. They are competing among each other, and in case of India, it also argued that has led to a new kind of federal market economy where states are directly negotiating with the foreign capital. So you find that, and so it provides a kind of experimentation, where you can experiment any policy initiative at a lower level, where risks are low, and if it is successful, it can be replicated at the national level or by other states. And for example, in India, for an innovative SMS system tracked approximately 1,200 newborn children in the state of Madhya Pradesh. So that reduced infant mortality. So this successful program was then replicated in other Indian states as well. Another important example I would like to mention is about the employment scheme called Jharkhand in the state of Jharkhand, Jharkhand State Livelihood Promotion Society, to generate employment, and that was very successful, and it was replicated by center called as Ajivika scheme by the federal government. Fourthly, I think one of the advantages of federal model of governance is that it allows for greater autonomy. So federal governance model is better able to respond to ethnic diversity and conflict. And this somewhere indirectly benefits women because they are disproportionately affected by conflict. For example, in Sri Lanka, I was going there as an expert when they were debating federal options. So in Sri Lanka, ethnic war between Tamil and Singla caused disproportionate violence against women of both the communities. Finally, I think a federal model of governance allows greater representation of local concerns, including women's diverse interests at local level. So priorities of women in different states are different. For example, in case of India, in state of Uttar Pradesh, northern states of Uttar Pradesh, and then Bihar, dowry, that is a kind of cash or property brought by the bride at the time of marriage. That is a very important issue. In state of Haryana, female feticide, that is a major concern. In state of Rajasthan, the lack of access to public space due to this ghungat or parda, female feels secluded. So different states have different concerns. Now coming to the disadvantages, on the other hand, gender scholars contend that federal model of governance limits opportunities for gender equality and advancement. Firstly, achieving uniformity may be difficult if subnational bodies are individually responsible for implementing universal rights norms. So rather, some gender scholars contend that a strong central government is required to ensure consistency of laws, programs, and services, especially with regard to distribution of powers. Scholars across the world, they believe that if women-related issues are more in the union list, there can be more uniform policies. But if they are in the concurrent, in case of India, then the concurrent list, most of the women-related issues. So, so if there's a conflict between the union law or the state law, the union law will prevail. So this is what the scholars observe. Secondly, one of the disadvantages of federal models of governance with regard to gender is these scholars argue that it is ineffective for advancing gender equality because it limits central government's power and fragments its ability to implement redistributive policies that benefit women and girls. Like in case of India, before this abolition of Article 370, there was no 73rd and 74th amendment that was there. So reservation was not there, so women could not be properly, represented. Thirdly, I think because of a federal model of governance, it focuses more on territorial interests and identities. It may be less responsive to gender equality reforms. Scholar Erin talks about this idea of concept of gender minority within minority. Okay, so like for examples, worldwide show that federations frequently tolerate, continuation of regional discriminatory practices, particularly with regard to inheritance and family law. And in India, with regard to Jammu and Kashmir, Article 35A, which was recently abrogated, that has been was considered to be discriminatory to women because women who married outside from the state lost property rights. So that is one of the disadvantages of federal model of governance. And finally, a federal governance model with multiple institutions is considered to be costly and complicated. There are overlapping concerns, multiple governments, multiple administration systems, multiple judicial systems. Citizens find it very difficult to understand and navigate. So which may result in less funding for gender equality and gender budgeting, especially in case of smaller and poor countries. Like when I was going to Nepal, when they were framing their 2015 constitution, I was going every year. So one of the major concerns, because it's a small country, was cost of federalism. Whether they can bear the cost of federalism, everything will multiply. Similarly, when Sri Lanka at one time was debating federal option, one of the major concerns was cost of federalism. Yeah. So further, I would say that in case of India, asymmetrical provision of power sharing, that also impacts gender. And I did mention about the case of Articles 370 and 35A, which was the most important asymmetrical provisions of the Indian Constitution. But the 35A was somewhat discriminatory to women, so it has been, abrogated. And but there are different laws, which are in some provinces they are pro women. In some cases, like in J&K, it was discriminatory to women. But in like Goa, they have Portuguese colonies of Goa and Union territories of Dadra and Nagar Haveli, as well as Daman and Diu. So here we have Portuguese law. So this legal principle required marriage registration and entailed an equal share in marital property, ensuring gender justice. So no sale, purchase, or charge on property could be made unless both spouses consented. theoretically, even rent agreements were to be signed by both spouses, even though this was frequently ignored. So, and then in northeastern states of India, like in Nagaland, Mizoram, Manipur, we find there civil society organizations like Naga Mothers Association, Meera PB, of Manipur. They played very critical roles, in engaging with intergovernmental differences on gender issues and facilitating a gender sensitive participatory planning framework in this case. So, sovereign leaders, they argue that these salience of territorially based identities, they have a very significant impact on women's politics. The greater the salience of territory, the more difficult it is to introduce gender as a political variable in federal political discourse. Now, in terms of representation of women, today, we have, 1.3, almost 1.3 crossed 1 billion in case of India, and in terms of the sex ratio, you'll find that it's 991 over 1,000, female to male sex ratio. So, but women are still underrepresented group in Indian Parliament, and their representation has remained below 15% in the national legislature to represent almost 50% of India's population. And Mary Jones explained this, that it is part of the legacy of the women leaders in the independence era, because women opposed women reservation in the parliament, and they considered it as pride that women in India always were equal to men. And therefore, in the national, we have introduced reservation in the local level, panchayat municipalities, 33% reservation. But in the national parliament and state legislatures, the reservation for women is still hanging fire, and there's an entire new debate regarding quota within quota, minority within minority, the creamy layer, whether so it is still hanging fire. And the question of political will is also important, whether the politicians are willing, to, all the bills are success women reservation bills. So whether there's a political will to introduce women reservation in parliament and national state assemblies. And then with regard to South Asia, like I'm more familiar with Nepal and Sri Lanka. So Article 84, Clause 8 of Nepal's constitution reserves 33% seats for positions for women in government institutions. And in the Supreme Court of Nepal, in fact, recently, instructed the government to issue a new bill in the parliament before consultation with women's groups. So there's more intergovernmental interaction, trying to involve women in decision-making process in case of Nepal. Now, Pakistan is one country where I would like to visit, but I never got an opportunity. But I do study South Asia. So Pakistan reserves 17% and 15% of parliamentary seats in the lower house and the Senate for women, respectively. While Bangladesh reserves 14, I did got an opportunity to visit Bangladesh when because there are some regions which are demanding autonomy. So Bangladesh reserves 14% of the seats in its parliament for women. And only 21% of Pakistan's parliament is currently made of women. And if the reserve seats are excluded, female representation in the National Assembly is around 3%. That is 60%, 60 seats are reserved for women. So these statistics reflect that especially in South Asia, male-dominated political culture is there, and along with other socio-economic factors, that creates a glass ceiling for women's political advancement. But surprisingly, Bhutan considers such a quota system undemocratic and has no quotas for any other community. Now, regarding the constitutional rights in case of Nepal, the 2015 constitution is a very progressive constitution, and they have given rights, different types of rights with regard to safe motherhood, reproductive rights. It's one of the progressive constitutions that they have reproductive rights also there. And no woman should be subjected to physical, mental, psychological. So right to participate in bodies of state, right to obtain special opportunities in education, health, employment, security based on positive discrimination. Spouse should have equal rights. So it's a very progressive kind of constitution as far as women's rights are concerned. Now, coming to Pakistan, I think Article 3 mandates the government to eliminate all forms of exploitation. Article 4 guarantees that every individual has right to be protected by law and to be treated equally. Then there are provisions for protection of women and children. Article 32 makes provisions for women's representation in local bodies and conditions for having humane working conditions. And Article 51 and 106 provide for reservation of seats in the legislatures for women. Now, in case of Sri Lanka, the Sri Lankan constitution does not recognize a right to substantive equality, bodily integrity, or quota for women's representation at local, provincial, or national levels. And the non-discrimination clause does not, explicitly mention gender discrimination as one of the protective characteristics. So, but Article 16 do ensure that a variety of laws continue to effectively discriminate against women. But Sri Lanka is not a federal model; it's a devolutionary model of governance. So, in the local authorities elections amendment act, the government of Sri Lanka adopted, 25% quota for appointment of women at the local level, government level, and the cabinet approved a proposal in 2016 to amend the provincial council elections. And patriarchy, that is still existent there in case of Sri Lanka also, and the national policies use discriminatory concepts also, such as head of the household, happy families, paternalist, guardianship, family background reports to inform variety of state policies. Bhutan, in case of Bhutan, the Bhutanese constitution provides the overall framework for promotion and protection of women's rights, and the gross national happiness development philosophy articulated the idea and vision of just and harmonious society. With regard to Bangladesh, they have the National Development Policy 2011 and its National Action Plan. They lay the groundwork for government action to promote gender equality. And the country has received international recognition for making significant progress on several gender indicators. And these include gender parity in primary and secondary education, as well as maternal mortality. So Bangladesh ranks, first in South Asia in the gender gap index, ranking 47 out of the 144 countries worldwide. And however, there are still gaps, and violence against women continues to be prevalent, and women face discrimination at home as well as outside in public spheres, marriage, divorce, child custody, maintenance, inheritance. All are governed by religious law in Bangladesh, and these personal laws frequently discriminate against women. So then just few quick examples about Southeast Asia, like in Myanmar constitution, because and Philippines, I did get an opportunity to visit Philippines when they were debating autonomy. And so in Myanmar, Article 347 guarantees equal rights and equal legal protection to all persons. And Myanmar ranks 96 out of 146 countries in 2011 gender inequality index, ahead of Cambodia and Laos. PDR ranked 99 and 107 respectively. So it has achieved, gender parity in education with regard to enrollment ratio of girls and boys in primary and secondary education. However, this aggregated analysis points to gender disparities in some of the poorest rural areas. Now, some key issues of concern include, high maternal mortality ratio, insufficient access to reproductive and basic health services, low levels of women participation in decision making, etc. And female participation in labor market is significantly below the men at 63.1% compared to 85.1% for men. And in Myanmar, only 4.4% of seats in the national parliament are held by women. Now, while the 2008 constitution guarantees women equality, it does not satisfy CWAW requirements to also define and prohibit direct and indirect discrimination against women. In Philippines, it is described to us a nation of strong women who directly or indirectly run the family unit, business, government agencies, etc. So, but Philippines has one of the smallest rates of gender disparity in the world. And in the global gender gap index 2017, Philippines ranked 10 And despite the comparatively advanced position of gender equality that the Philippines maintains, gender-based violence towards women, particularly domestic violence, remains a pervasive problem there. So to conclude, I would say women in South Asia speak and lead. We need to decolonialize feminism. As Western scholars, they have projected the South Asian women, as backward. But we got the voting rights in case of India also right in the constitution, and India has the most powerful women leadership like Indira Gandhi was the prime minister. Many states, provinces have women chief ministers, and the present president of India is women. And similarly in Bangladesh, women have played a very important political role since the country's struggle for independence, and women were also involved in resistance movements in Bangladesh, and were active and raising voices that were issues that were particular to them, and particular as part of as a result of that, Article 28, was included in 1972, the constitution that talks about gender equality between men and women. So Sheikh Hasina was the current prime minister of Bangladesh, has been more active, in politics for more than 4 decades. And then Pakistan, again, we have the youngest and the first woman foreign minister, Hina Rabbani Khan, was known for representing her country on different global forums and as an active public speaker. And in Sri Lanka, again, we have Chandrika Kumartunga, and she has played a very important role in the country's political scenario, and she served as the president, where her work was very instrumental in ending the Sri Lankan civil war between ethnic Sinhalese and the Tamils. Even in Nepal, you'll find the Vidya Devi Bhandari is the second and the current president of Nepal, elected in 2015. And and according to Forbes, Forbes placed her on 52nd position in the list of the world's 100 most powerful women in 2016. And women in US, but in US now, the most oldest federal democracy doesn't have a women prime minister president till dates. And then Benazir Bhutto in Pakistan was the first female head of the state of a Muslim country, and twice became premier of Pakistan. So
we need to conclude.
Yeah, just one line to conclude. Though I would say patriarchy is a universal phenomenon, and the struggle against patriarchy has been waged in all the countries, and all of the rights that women have got are product of the feminist activism. So but the nature of patriarchy has varied, from in forms of struggle, diverse parts of the world, and in South Asian region, patriarchy intersects with the religion and caste. Therefore, intersectional theory that talks about the differential experience of women based on differential identity axis along gender, caste, class, and religion seems most relevant to analyze women's position in the countries and feminist stance on issues such as personal loss. Thank you so much.
Good. Okay, thank you for this fascinating overviews. We now open up for questions or contributions from the audience. Who wants to go first? Okay.
Good morning, everyone. So it was a quite insightful lecture from all the presenters. I enjoyed personally. My question is, Delaney, I just want to know, if you look at a larger area of judicial federalism or legislative federalism, have there ever been significant judicial pronouncement at federal level or for that matter state level, and any coordination between the federal laws and state laws, mostly with respect to the issue of marital rape? That's the question.
So if I understand correctly, you're asking about whether there has been a Supreme Court statement on marital rape. I don't think so. I can't think of one off the top of my head. But I would have to check Westlaw and be 100% sure. The complexity of the ways in which rape is regulated at the state level is a topic that is a very intense and much litigated topic right now. A colleague of mine named Deborah Turkheimer has written a very important book on the idea of credibility and incredibility and whether or not women receive credibility discount when they're operating in criminal prosecutions. We talked yesterday a little bit about the Violence Against Women Act and the idea that the federal government tried to incentivize or help victims of domestic violence by authorizing a civil remedy against their perpetrators that the court held unconstitutional as outside of the bounds of what Congress could legislate. Because it felt like domestic violence was not being taken seriously in many states, even if there are laws on the books preventing rape. Some states require, it varies state by state, and as I'm not a criminal law professor, I can't tell you the details on where it is in state law. I will say that the assumption that the touchstone is consent is not true across the country. That is not necessarily the baseline in every context in every state. That is something that many groups are pushing to be, affirmative consent. Yes means yes, and movements like that. But that is not what the law is in many places. So there's kind of a disconnect between the law on the books and the law that is verbalized and being tried to put into place in things like college campuses, where there are approaches to these kinds of relationships and gender equality issues that are kind of outside of the law, but are more policies that are trying to be in.
Thank you for your presentation. I was wondering if there's more general question and that's many of you. From your presentations, I get the impression that protection in federal systems or decentralized systems is can be better at least, but not only because decisions are made closer to citizens, but also because some sort of incentive is introduced so that subnational units compete among them. So at the end of the day, it's more than the ideological acts, more than the moral philosophy behind this, than the territorial acts, the aim at competing among them is what drives for this. So it's a bit. How much weight does the values or the moral philosophy behind this have? And are there studies that try to demonstrate that protection is bigger, is being enforced in decentralized states than compared to unitary states? Is protection weaker in France, so to say, because of this? Or is it more effective to protect rights through these incentives as rather through an ideological discourse?
Okay, who wants to go first? May I ask you?
I guess Professor Rekha can start because they have an older historical decentralization.
Yeah, I think even former federation has conducted a series of research on this, and the research suggests that federal model of governance has are better for gender equality and moreover, but there are disadvantages and advantages as I mentioned and my colleagues mentioned. But there are, this is again an area which is not much explored, and so I think it needs to be studied and explored by researchers. There are not many studies on this. So, but whatever studies have been done by former federations suggest that, federal model of governance is better because it tries to accommodate diversity and the minorities within minorities. There are provisions for protection of minorities within minorities, as we all mentioned in our different case studies. And as government becomes closer to people, it provides different opportunities at different levels for forum shopping, venue shopping, policy experimentation at different levels. So, but then there are challenges, but it is different. There's no one model that I can suggest that there are different challenges in different countries, different models. There's no one ideal model. So, but it depends largely on the historical context and the cultural and historical context where that tradition is rooted or models. That is very important. And the political will of the leadership, what do they want? Like in the case of India, I mentioned about this reservation, women reservation bill, that India got, voting right in the constitution, women get voting right. And, but still, in local government bodies, we have reservation, 33% reservation, but in some states like Bihar, 50% reservation for women. But in national parliament stages, we are still debating that option, but there are other constraints like other banning for quota within quota. And one section believes that we don't want the creamier to get all the benefits. So this bill is still having was passed in one house, but still not really passed in both the houses of the parliament. So you can, I think, my other colleagues can respond now.
As you know, in our case in Jordan is new in its decentralization process. It has been only 6 years. We can say that now with the decentralization process, we are better in terms of planning and identifying local needs when it comes to local councils compared to keeping everything in the hand of the centralized government. And therefore, we can say that this is an advancement in terms of decentralization, and women having the right to plan, the right to identify what are the needs from a gender perspective. It's now becoming an important issue in Jordan, which was not the case before. I can give an example for in my work in the form of federation project. We had many dialogue between women at council levels to identify climate issues, climate concerns, local issues. And we noticed that local councils, they know more of the climate challenges at their communities more than men. And even they know more better what Jordan has signed in terms of international agreements. So they are not only knowledgeable about the challenges, but also they are knowledgeable about the Jordanian, let's say, policies and international commitment. And this will be very important. If they were not part of the council members talking, we would never know what women are capable of knowing and implementing. And also they push hard in many governorates in Jordan that there are, let's say, environmental monitoring to prevent, let's say, the theft and the fires in our limited forests in Jordan. So this was all the work of women via the being members of council members. Just to mention that maybe also parallel to the local council, we started noticing there is local media occurring, being established in many governorates, and this also helped in identifying, as you said, if there is security issues, if there are violence cases against women. It was more, it's now more obvious and more clear and can be documented better because we have local media that is getting stronger. So just to mention, this is the case of Jordan. Thank you.
I just love that question because it just gets to the heart of the tension between law, constitutional design, structure, and culture. I mean, hard pressed to say that Sweden doesn't do a better job, right? Ruth Bader Ginsburg went there, and part of her understanding and strategy came from her experiences in Scandinavia. So I think the question is really not, can you give up the social movement, cultural motivation and engagement that any society needs to effectuate real change, but just what are the range of opportunities a particular structure gives you for fostering that social movement, engagement, and cultural change? And does the structure facilitate that or hinder that? And I think the comments suggest it can go either way. I mean, it's very easy to say, oh, it's hindered, federalism hinders if you have a strong central government that wants to do great things and states are problematic. And then you say, well, but federalism is wonderful if you have a weak central government that doesn't do the things you want to do and you can do it at your state level. So at some, I think in particularly you see this in the United States, there's what federalism means is often only identified through the lens of the issue that is being navigated. Oh, federalism is good, federalism is bad, and you see people switch sides based on what the substantive issue is. I think that the commitment to federalism as a structural matter is a commitment to the sense that through this decentralization, through the multiplicity of legislatures, through the structural benefits that federalism provides, more often than not are going to allow for the kind of vibrancy and social movement, change, engagement, and evolution over time that at least prioritizes, we hope, some element of democracy and liberty, if, you know, whether or not the arc always bends towards progress, which, you know, we hope it does, but maybe it doesn't always.
Can I add something? One point I missed, you asked about the competition, that point I missed. Yeah, so I think in federal model, especially in case of India, with privatization and globalization of the economy, we find that, and with party system change from one party dominance to multi-party system, and with judicial interpretations favoring because of state autonomy, the focus has shifted from center to states. States have become their laboratories, and they are directly negotiating, as I mentioned, with foreign capital. They are generating their own resources, and they're competing among themselves. That has increased. That's what you talked about it. That has increased the competition among states. They are trying to compete among themselves. So I think that's a healthy practice, and so we don't have just strong center, we have strong states also. So I think that's the real situation in India. We have the states have become very important, especially foreign policy treaty making power is very important, though it's an executive power in parliamentary federations, but with privatization and globalization, states are negotiating with foreign capital. And there were a case when India signed WTO treaty in 1995, some states were not consulted by the center, like Tamil Nadu, Punjab, so they filed petition in the Supreme Court that they were not consulted in areas that fell in the exclusive jurisdiction also, like agriculture. So there was some kind of assurance that in future they will have some consultation before entering into treaties. So things have changed, and para-diplomacy, they are playing more important role in para-diplomacy. Thank you.
Thank you. Please.
Thank you very much, and for the excellent presentation. Of course, my question is touched by the former colleague, and I want to ask, how do you see to have these good laws in Jordan, in India, and the laws are changing the family, the constitution laws, contribute to the gender party. But do you think that these laws are enough by itself to bring this gender equality? But when I say this because in Ethiopia we have so many golden laws regarding gender equality, but the issue is not still touched. So what their experience, do you think that is there any change after we have these laws and this federal system in your country? Do you think that gender pay fairness decrease, the women participation in politics increase? How do you see the contribution of these legal framework policies to be gender equality? Thank you very much.
Thank you for your very important question. And it, I might answer this question from my experience as a project manager, because we're working side by side with women decision makers, with future generations, in order to create, as you said, this environment that allows the implementation of these legislations and the better positioning of gender equality in Jordan. So I can say, as you said, constitution and laws are not enough. One of the things that we're trying to foster in Jordan is networking among women in various fields. For example, we're trying to support network among women working in the public sector, to have dialogue and experiences, identify challenges, and try to find solutions. Not only at Jordan level, but also the Forum of Federation is opening this dialogue with other countries like Morocco and Tunisia. And this exchange of experiences enriches women experiences. As you know, they started later than men in the public sector. So this helps to close the gap. So this is one important thing. A network among parliamentarians, women parliamentarians, among women in public sector, even women in local level councils, opening this and networking is very important. On topics, as my colleague mentioned, gender budgeting, gender equality, human resource level, all these topics, learning how to negotiate your rights, in particular women represent due to quota, they are minorities in the council. So they need to lobby, even with members of the councils, in order to get to advance their ideas or their projects. So how to negotiate, how to lobby, it's also techniques that we women need to mobilize in order to have our, let's say, thoughts and views and vision becoming a reality. As I said earlier, youth, we believe in that young generations will have a role in the future in terms of building their capacity and raising the awareness about gender equality and how it reflects into better development in the country. As my colleague said, we represent 50% of the population. We have the right to have a decision making in all levels, whether national or regional, and this will reflect in a better welfare, better development in Jordan. So all this, as I said, and finally the awareness. We also raise awareness among all levels of communities, among students, whether among council members, civil society organization, on the importance of gender equality. All this, along with the legislations and constitution, we believe will have an impact. It's not in the short run, but I believe in the medium and on the long run. Thank you.
Thank you so much for your very important questions. I think, as my colleague mentioned, it's constitution and laws, they are important. But then what needs to be done in case of India, also we have very good laws on paper, but they have to make more stringent, and we have done so, like after this gang raid that I mentioned, there's Vishaka judgment. So there's need to make more stringent laws. And then secondly, I think there's need to introduce gender as a variable in political culture. And thirdly, I think education and awareness, as mentioned by my colleague, was very important, because like in India, we gave 74% reservation to women in panchayats and municipalities. But the concept of sarpanch patis, women husbands, panchayat patis, they emerge. Women men on behalf of their women, they used to take all the decisions. So, but the NGOs played a very important role in organizing awareness camps and educating women about their rights. And now things have changed. And I remember one of the minister of Comparative mentioned that in one of the villages they went and the women, husband of that Sarpanch was sitting and he was giving orders, but the moment women can just vacate my seat now and then. So they are now becoming more aware of their rights and they are, so that is education, awareness. And it is not just the responsibility of the state, it is a collective responsibility of states and civil society. Thank you so much.
I think Professor Delaney has other opinion.
Oh, no,
No? Okay.
I mean, I much like the previous question, right, does law matter? And I think at some level, we have to believe it does, but as you just heard, it only matters to a certain extent. I mean, at some level, right, there's some blame on the West, on the State Department from the United States, on Venice Commission, on all of the organizations that push constitutionalization and a focus on text, occasionally courts, often courts and text together, and they're not as much in Ethiopia, but that somehow is the solution, but not absent these on the ground, in robust engagements with how you operationalize a system like that, whether it's learning how to access your rights, learning how to protect them. And so, but that said, you can't throw the baby out with the bathwater, right? There is something you asked about the United States, or you didn't, but I will say something about the United States. That's why I'm here. I think it would be really meaningful to have an equal rights amendment. Even if Justice Ginsburg was right in saying it wouldn't operationalize things that much differently, even if a conservative Supreme Court interpreted it narrowly, the commitments in a text that is meant to represent the country to equality for all within that are major commitments, and it's something to point to, and it's, we've had many people in the United States that have spoken to the promise and the aspirations of our Constitution. Frederick Douglass, we talked about yesterday, Martin Luther King Jr., you have to kind of aspire to that, and if a Constitution is also aspirational, it can be demoralizing, but I'm not sure that it means you shouldn't have those aspirations.
Thank you.
For lawyer.
Please.
Thank you very much for the restricted and interesting presentation. This is actually reminding me with my country, so I came from Sudan. And when it comes to the gender issues and the system, actually it's depends on how the system is structured and how this is allowed women to be more representative within their the political processes in general, in the parliament or the decision making level. So this is really very important because when it comes to the national level or the upper levels, sometimes we find some constraint regarding that actually. And a part of that was mentioned about the social issues and norms and your traditional custom and all these kind of things. And also, I think it's more about the quality of the people that are the women that represented for them actually. Because in 2005, we have a quota, we fought for the quota, we have 25%. They are there in the parliament, but unfortunately, they are like very weak to like represented women in a very good and advocated for the right issue. So even you see that it's gender violence is actually there, the constitution, the law status of Christian or other groups. So it's really sometimes it's complicated. So it's more about the quality of women that is within this system and representing the other. So my question is about actually for gender for the Jordan, and India, because you mentioned something about the civil society and the government advocates for the rights of the women, for example, in gender and social matters. So we'd like to talk about if there is time of like a protection of the women's rights within the constitution, if there is like mechanisms that can preserve these rights, and at the same time they can review and see if these laws, different laws, because as we mentioned by our colleague, there's many laws, so if these laws will be aligned with the constitution. In other cases, now we are reviewing the constitution in terms of the Italian constitution for 3 years. So women, they came with the idea that is the gender gap within the constitution. So they identify that, and within one that there is like they call for like a constitutional right for women, and a mechanism that to review the constitution itself and other laws to ensure that this woman will be like in a good position, and no one can, for example, make them less like for their ecosystem.
Okay. Okay, thank you so much for your very important intervention. I think you rightly mentioned that it's not numerical presence is not important, but politics of presence, that is also to some extent numerical strength of women in different institutions is also important. But what is more important is substantial representation of women. How far they are able to contribute, in decision making, and are they able to let's bring out some legislation, influence any legislation, or raise questions in parliamentary, contribute in parliamentary debates. So substantive representation is very important. I think first step is numerical representation, next step is substantial representation. So, and then you asked, next question was related to civil society. Yeah. So like in India, of course, in other countries like other countries in South Asia, also in India, we have institutional mechanisms. Besides the constitution, I mentioned the laws. We have National Commission for Women, that looks into such issues, and if there's some complaints, they look into them and act. And then the civil society also organizations are very active in India. And I did mention about that. Probably the case where it was taken up by a women's organization, the Shakha, and then I'm also part of many women's organizations looking into school dropouts and in different cases. So I think women organizations do play a very important role in raising up the cause of women. So, yeah.
Yes, thank you for this very important question, and I guess Jordan and Sudan might have similar challenges in that term. From my humble experience, we have started our project in 2018 and now it's 2022. And we had during that time two parliamentarian elections. And we have two different set of women parliamentarians that came into, let's say, legislative power, except one. So this means that even the women that we had accompanied in terms of capacity building and dialogue were not able to win the second round of parliamentary election, and now we are getting to work with a new members of parliament, and that's a challenge in Jordan, how to assist women to stay and be successful in their political life. This is a challenge in Jordan. And also the challenge of equality versus democracy. I'm not sure if this is correct in political terms, but when it comes to local level, is that the law allows men and women who are of 25 years old to run for local councils. So this means young people, but with less experience. So, and sometimes they are still studying at university. With less political experience, but they are there. So are we looking at quality or at local level, or is it like we want to build the capacity of those young people to have experience so that when it comes to national elections, they can go and run after having experience at local level? So it's a challenge to look at that. So yes, at local level, we face quality issues in terms of members of councils. But they represent the communities, and sometimes there are numbers who are really of let's say not educative backgrounds, strong educative backgrounds, and that's why we are trying to innovate tools to assist these council members to plan and strategically, even if they don't have this, very vast educational experience. For example, I was part of a local experts who developed what we call a scenario planning tool. It's a tool that assists council members to plan in a very simple methodology without needing to have, experience and knowledge in strategic planning and all these issues. So we have to overcome, as you said, the quality issue and assist those council members to plan for their communities.
Okay, we're
Can I just add one
Yeah.
point? Sorry. Yeah, I think in India, women's movements have also played a very important role, and in raising up different issues. But the problem is that they take up so many issues at one point. So it has to be more focused. And then remember, there are many cross-cutting identities. So class, identity, overshadows women, gender issues in case. So class issues become more important than gender. So cross-cutting identities that also affects women, issues. Thanks.
okay. We're coming into the concluding phase. I was asked to summarize, and I think it's important. So
One last question.
there is one. Okay, one last question.
So.
Okay. Then please select the questions, please.
Yes, gender balance.
My question is much more general than the ones before. I'm just curious, if we look at about 100 years of advancement in women's rights, is there a difference between countries with a federalist structure and countries with a centralist structure in being conducive to such progress?
Thank you for such a wonderful presentation, I would say. And mine is more like a comment than a question, because what I would say is that we should not miss the roots from the trees. Because it's a very gradual process, and we all know it. But coming from the perspective of post-colonial or South nation, I would say that when it comes to participation and empowerment of women, it changes the whole dynamics and the whole game. So I'll give you just two examples. There was a research which was done with respect to the local self-government and women represented in those institutions in India by Philip Banerjee and Sindhu Flow. And they said that, if you have a woman at the top of the local government, then the issue of water would be most importantly addressed than if you have no woman at that level. So for countries in North, water is not a big problem. But for countries in South, 60% of the homes do not have safe drinking water. And if you have a woman at the helm of affairs, because water is a local issue, then the most important thing and the agenda for her is to ensure that she gets a clean drinking water for every home at the local level. The second was done by Rekha Banerjee, and she said that if you have a woman elected official at the local level, the chances of cases which are crimes against women being reported are 90% more than if you have a male head at the local level. So you all know that policing is basically, a male-dominated area. So sexual harassment or cases of violence against women also fail to get the requisite justice. But if you have a local official at the local level with also a woman, then there's hand holding. The passage is quite easy. So these are certain examples that completely changes the game. Because if there are no women, there are no changes at the local level. So if you think that women, and if they get certain rights, they'll just change the whole world in one day, you know, it's actually a very impossible proposition. So like Gandhi, it is also a gradual, one step at a time approach. And similarly, I would like to know from Professor Khrais that, you know, do you have such an example or such a story from your end? Because, you know, mostly I would say that the concerns are almost similar when we compare the two sides. Thank you.
Okay, thank you for these two questions. One, okay.
Thank you for wonderful presentations. I have a question. Probably I just wanted to add this insight into this whole presentation. When we talk about gender equality, do you think it is important to include those people who do not fall under the category of two dominant genders, that is male and female, that is not transgender people? How important do you think it is to include them into the legislative processes and part of the whole, you know, international politics or national politics? Thank you.
Okay, that's now again a bit of a broad okay. I'm gonna still ask you to be short because we're running out of time. Please, Professor Rekha.
Okay. So I first respond to your question. I think I will argue that and many scholars working on federalism, they argue that federal systems of course has advantages. You know, it has then as compared to a unitary system, you know, federal system to support the cause of gender equality, because we have different tiers of governments. So women can get opportunity to participate in contesting elections at national level. If they don't get ticket, they can contest at state level or local level. So it increases political participation of women, you know, but because there are different levels of government. Similarly, I mentioned during my presentation that women, in case of their reforms, issues that they raise, women's movement, if the central government is not very supportive, it's conservative, they can shift their focus to state level. So you have different levels, so where they can raise their issues or demands. There are different platforms, and so these I think federal system and then gender budgeting. I did talk about forum shopping, that they can experiment policy innovation at one level. So different federal system definitely have greater advantages that compared to unitary system, because it provides different level, different women, diverse interests of women that differ at different levels. So that can be accommodated, and federalism is more sensitive to diversity. So I think federal system as compared to unitary system is more, you know, supportive of the cause of women. And let others respond, then I'll answer the last question. Sorry. Thank you.
Yes, I will answer directly to the questions comparing what's India versus Jordan in terms of the the advantage of having women at council levels or women in charge. I can say again from my experience, we have conducted a capacity building for women working for government. It's called like, you know, the gender equality unit at the various ministries, and we noticed that women who took this capacity building course on gender equality and human resource were able to amend the internal policies, human resource policies within their governmental entities to tackle the issues of sexual harassment and violence in the institution. They took it more seriously. So this is to compare this thing. Another thing at the parliamentarian level, women parliamentarians who faced political violence, they are the ones who were able to speak courageously about the issues that they have faced and try to establish a network to face this political violence. We agree that political violence, men and women, they face it when they are candidates to in elections. But women, they are hit harder in terms of political violence in Jordan, in particularly when it comes to social through social media. I guess, as you said, women are advancing solutions to issues they face when they are in decision-making position. And I have mentioned to you the example of women who know better the local climate issues, and they are the ones who are fighting hard to prevent the abolition of the limited forests in Jordan, because it affects them, their children, the balance in their environment. Here are a few examples that I can share with you, and if I remember more, we can discuss during lunch.
Actually, there was one more question addressed to me.
Do you want, you can,
Just, yeah, so there was one more question regarding sexual minorities. So I think according to this section 377 in case of India of Indian Penal Code, it was the colonial law and that had criminalized same-sex relationships, but it has been decriminalized in NAS Foundation versus Government of in NCT of Delhi case 2009. So that this has been decriminalized LGBTQ relationship. So it has been repealed in case of India. Right, you were talking about the rights of sexual minorities.
I'm actually talking about representation of those minorities in the legislative system.
I'm not aware of any such study. So, but there's need to be more researchers can work in India. But it was a criminal act, but now has been decriminalized in India and with regard to LGBT relationships. Thank you.
Okay. Okay, probably there will be other opportunities to talk with the speakers on the podium during the remaining days of the winter school. I want to thank you in the audience for very interesting questions, for a very interesting contribution, and above all for the three speakers at the podium. And I think they deserve an award.